Good morning. I'm David Goldstein. I'm the founding partner of the nonprofit tax-exempt religious organizations practice group at the Certilman Balin Law Firm on Long Island. And I'm going to be talking to you about today's legal update. And by the way, in your materials, you have my PowerPoint and some supplementary materials as well. And we'll probably talk a little bit about those. So what we're going to focus on today are takeaways and what we can learn from the New York Attorney General's complaint against the National Rifle Association of America and some of its senior officers, including Wayne LaPierre and some others. And this complaint is in your materials. And what I want to emphasize at the outset is that it's a complaint. It's chock full of allegations. They're very well documented allegations, as you're going to see, but I do want to say that at this point there's still only allegations and they haven't been fully adjudicated, but they are based on extensive documentation and interviews with the parties involved and other witnesses. So I definitely commend the complaint for your review, but we're going to highlight some aspects of it here and try to focus on some of the takeaways for nonprofits in general. So what we see is that there are certain provisions of the law and board responsibility that are repeatedly featured prominently in enforcement actions by the Attorney General's Charities Bureau and also in actions brought by individuals with standing to sue under the law. And those individuals with standing could be members of the board of directors, officers, or members in the context of a member nonprofit. And those individuals, directors, officers, members, have standing under the law to bring a suit on behalf of the corporation against directors or officers. And then, of course, there are enforcement actions like the one we're going to be delving into that are brought by the Attorney General's Charities Bureau. And we see the same key provisions of the law and of board responsibility that pop up over and over again in enforcement actions and in litigation. For example, in the Attorney General's action against the Trump Foundation and its board of directors that was concluded maybe a year or two ago, the focus there was on a series of significant related party transactions between board members and the organization, and also the absence of governance and oversight. And in recent litigation by the bankruptcy trustee in the Dowling College bankruptcy against the trustees and officers of Dowling College, the focus of that complaint in that action was, and that's an example of a litigation against a nonprofit board, not brought by a regulatory agency, not brought by the Attorney General. The focus of the bankruptcies complaint were deficiencies in oversight by the board and the absence of timely and accurate information flow to the board. And in lots of litigations against nonprofit boards and also in internal disputes, and we get those walking through our door continually. There's really been a crescendo in both internal disputes and litigation involving nonprofits. And what we see over and over again in those situations are allegations of deficiencies in board oversight, absence of timely and accurate information flow to the board, related party transactions, and the absence of and deficiencies in corporate governance by the nonprofit. So you're starting to see a theme here, and not surprisingly, we see most of these same provisions of the law and board responsibility at the heart of the allegations in the Attorney General's NRA enforcement action. In addition, in this NRA enforcement action, we see the critical role of the Audit Committee and audit oversight in the Attorney General's complaint. And that's something I'm going to delve into in a little bit of detail as we go forward this morning. So the complaint by the Attorney General's Charities Bureau against the NRA and these individual NRA defendants is quite lengthy. It's 169 pages in length without exhibits, just the complaint itself. It has 666 numbered paragraphs, chock full of jarring detail. There really is a trail of incredibly egregious behavior that's alleged in the complaint. And the magnitude is quite shocking, even for people who are used to looking at allegations of wrongdoing in the nonprofit context. Really, we're talking here about allegations involving many tens of millions of dollars of financial improprieties. And chief among these improprieties is astronomical compensation for senior officers and for others, some of their affiliates, also for board members and other insiders, but in particular for senior officers, quite astronomical compensation, much of it hidden. And there were arrangements where vendors, third-party vendors, and we'll get into this in a little bit more detail, and certainly it's explored in tremendous detail, including through documents and witness testimony in the complaint. Vendors would pay personal fees or expenses of senior officers of the NRA, and they would then invoice the NRA for these payments disguised as a vendor charge. And so on a vendor invoice, there would be a line item for reimbursement of expenses without detail, and the NRA would reimburse those expenses, but in fact, those would have been personal charges that the vendor paid on behalf of some of the senior officers. There were also no-show jobs for insiders and their relatives. There were expenditures to facilitate a lavish lifestyle, including lots of private airplane flights, vacations in exotic locations, at luxury resorts, including for relatives, and lots of other personal expenses were paid. In one instance, and this jumps out as being particularly egregious, a relative's wedding was paid for using charitable assets through this same sort of arrangement, where it showed up on a vendor invoice as it was paid directly by the vendor, and then the vendor got reimbursed for those expenses by the NRA. So while the wrongdoing alleged in the NRA case is extreme, I think you get that sense hopefully already, and over the top, what's important for us in terms of the takeaway is that the legal underpinnings of the Attorney General's case are incredibly relevant to every single New York nonprofit, because in fact your organization is governed by precisely the same provisions as the NRA is governed by, and your board has the same responsibilities and compliance obligations as the NRA's board. So you're dealing with these very same requirements and fiduciary duties and processes and procedures. Put another way, when my firm is asked to become involved in internal disputes, litigation, and Attorney General investigations involving nonprofits, we see the same legal underpinnings at play as in the Attorney General's complaint against the NRA. So there's lots for us to learn from the contents of this complaint. So let's jump to some excerpts from the complaint. From paragraph 581 of the complaint, referring to Wayne LaPierre, who is still the executive vice president of the NRA and functionally runs the NRA's operations. LaPierre breached his fiduciary duties of loyalty, care, and obedience to the NRA by using his powers as an officer and ex officio director. Ex officio basically means by virtue of his office, he was also a member of the board of directors, although a non-voting one. So ex officio, by virtue of his office, he was a director, to obtain illegal compensation and benefits to convert NRA funds for his own benefit, and to dominate, control, and direct the NRA to obtain private benefit for himself, his family members, and for certain other insiders, including a couple of the other defendants, Phillips and Powell, in contravention of the NRA's bylaws, policies and procedures, and applicable laws. That's a quote directly from the complaint. And of course, highlighted here, if you've seen me speak before, you knew that this moment was coming. Fundamental to New York nonprofit law, fundamental to any action against a board or officers, be it a regulatory action like this, Attorney General action, or an action by litigants. Fundamental are the fiduciary duties that a nonprofit director has under the law. And of course, if you're a director and officer and you breach those duties, you have potential personal liability. And those are the duties of loyalty, care, and obedience. It's the basis of the Attorney General's action. And let's really quickly review those three duties. The duty of care is set forth explicitly in the not-for-profit corporation law, Section 717A. A director must discharge the duties of his or her position in good faith and with the care an ordinarily prudent person in a like position would exercise under similar circumstances. And this is basically the board's oversight function. But it's not oversight from 10,000 feet in the air. It's not oversight from 10 miles away. It's hands-on oversight. It requires familiarity with the organization's finances and activities and regular participation in its governance. Second of the three duties is the duty of loyalty. A director must act in the interest of the organization. This requires undivided allegiance to the organization's mission when using the power of his or her position or information concerning the organization or its property. And we see this duty, the duty of loyalty, all of the time in the areas of conflicts of interest and related party transactions, which, as you're seeing, plays prominently in lots of nonprofit enforcement actions and litigation, and certainly in the NRA complaint. The third duty, which is a really important fiduciary duty that's often overlooked because it doesn't exist in the for-profit world, but it does exist, and it's particular to nonprofit law. It's the duty of obedience, and it really is what it sounds like. It's the duty to ensure that the organization complies with applicable laws and regulations and its internal governance documents and policies. Now, I highlighted and bolded internal governance documents and policies because, interestingly, and we're going to touch on this a little bit, the NRA, because it was an organization with such substantial resources, both on the staff level and on the external resource level, law firms, accounting firms, etc., there were some pretty decent governance documents, policies, and procedures in place. But we're going to see that that's not enough when you make exceptions to those very policies and procedures and you ignore them. And of course, one aspect of the duty of obedience is obeying your internal governance documents and policies. The other aspect is knowing and obeying laws and regulations, which again is very prominent in this complaint. And compliance with applicable laws and regulations is even more difficult than it sounds because there are multiple layers of laws and regulations. As we know, there's federal law, and in the nonprofit context, the Internal Revenue Code. In particular, there's state law, the not-for-profit corporation law. Other laws, we'll see that the Estates, Powers, and Trusts law is mentioned in the complaint because that governs the use of charitable assets. There are aspects of the executive law that are relevant, and that deals in the nonprofit context with annual filings by nonprofit organizations. So there, and then just to make things interesting, there are also local laws that nonprofits need to be cognizant of, and all of that is part of the very hefty duty of obedience. So in the NRA complaint, as I mentioned earlier, the role of the Audit Committee is critical. And the Audit Committee is very important in the nonprofit governance regime of New York State. The Audit Committee is the only committee with an entire section of the not-for-profit corporation law dedicated just to its functioning, and that's Section 712-A, and that is the audit oversight provision that was added as part of the Nonprofit Revitalization Act of 2013, and it's a very important section, very detailed, and the Audit Committee is a central component of the governance structure under the not-for-profit corporation law. And in the context of the NRA, we really see an epic failure of the Audit Committee. This is quoting from the complaint. The Audit Committee failed to perform its statutory, bylaw, and charter responsibilities as set forth in the preceding paragraphs. As a result, and those are important words, as a result, the board was unable to exercise its responsibilities to maintain a system that was reasonably effective in identifying violations of law. In turn, the board displayed a sustained and systematic failure to exercise their oversight function and stood by as various laws were violated by the NRA. And we'll get to that, including in a minute. I want to just touch on that as a result. The as a result piece gets to the committee format and structure under the not-for-profit corporation law and the way committees work, which is why board committees can have as voting members only board members, because the board is delegating a piece of its functioning and authority to a committee. And so when the committee drops the ball, as a result, the board fails in its oversight function. So that's how some of those pieces fit together. And so here's that, including, and so there were, and again, this is quoting directly from paragraph 531 of the complaint. There were violations of the NRA's tax-exempt status, false reporting on annual filings with the IRS and the Attorney General's Charities Bureau, improper expense documentation, improper wage reporting, improper income tax withholding, failure to make required excise tax reporting and payment, payments in excess of reasonable compensation to disqualified persons, meaning insiders. It's a defined term under the Internal Revenue Code, and waste of NRA assets. As I mentioned earlier, in some critical respects, the NRA lacked appropriate policies and internal controls, but in others, the policies and controls were present but ignored, disregarded, and exceptions were made in practice. A prime example was if the NRA had controls and a process in place for entering into significant contracts, which, if followed, could have prevented many of the missteps that are detailed in the complaint. Unfortunately, these controls and policies were ignored, with disastrous consequences for the organization, for its assets, for the board members, for the officers, the senior ones for sure, who are defendants in this action. Quoting from paragraph 476 of the complaint, the culture of non-compliance and disregard for the internal controls was evident within the NRA Audit Committee, which similarly failed to fulfill its obligation to oversee internal controls. This lack of oversight resulted in waste and loss of the NRA's charitable assets and contributed to the NRA reaching its currently deteriorated financial state. So making exceptions to the requirements of the contract approval process opened the door to rampant abuses and permitted contracts and arrangements that improperly benefited board members, officers, their family members, and their business affiliates. What we have here is a case of file cabinet syndrome. While not as headline-worthy as the NRA's missteps, in our own practice at my firm, we often see nonprofits falling victim to file cabinet syndrome. What is file cabinet syndrome? That's when a nonprofit goes to the trouble and expense of developing and adopting an effective policy, but then files it away, loses track of it, disregards it, makes exceptions, and thereby creates a breach of fiduciary duty by its board members and officers, because remember that the duty of obedience requires following to the letter, with no exceptions, uh, your internal governance policies and requirements. Part of what facilitates file cabinet syndrome is that nonprofit board members and officers fall victim to the dreaded T word, which is a word that should not be uttered in the nonprofit governance and internal controls realm because it is entirely incompatible with proper governance and adequate internal controls. What is the T word? Hopefully some of you have guessed what it is, but here we go. It's trust. Trust is incompatible with nonprofit governance and internal controls. And here, quoting from the complaint, paragraph 527. For example, the vice chair of the audit committee of the NRA testified that he did not feel the need to ask RSM, the NRA's external auditor, for external oversight of LaPierre's expenses because he, quote, personally had a great deal of trust in Wayne LaPierre, and he didn't believe that LaPierre expends money unnecessarily. Another syndrome that we see afflicting nonprofit officers and board members in general, and this can also lead to all sorts of breaches of fiduciary duty and potential liability. Another syndrome is, and we also see it, of course, here in the NRA dynamics and in this complaint, is ostrich syndrome. And that's basically like an ostrich burying one's head in the sand and pretending not to see what's right there in front of you. And you can categorize this as hear no evil, see no evil. And if you're a generation and remember the Hogan's Heroes TV show back in the day, there was a character on that show, Sergeant Schultz, and his tagline was, I see nothing, I hear nothing. So hear no evil, see no evil, bury your head in the sand. And so here's another excerpt from the NRA complaint. Just to set the stage, on July 30th, 2018, whistleblowers on the NRA staff were scheduled to present their concerns in detail to the board's audit committee, including a report known as the Top Concerns Memo. And a lot of those top concerns wind up as the top aspects of the Attorney General's complaint. So they were going to present on July 18, 2018, an appointment with the Audit Committee to present these concerns, including the Top Concerns Memo, to the Audit Committee. And this Top Concerns Memo laid out the egregious conduct and financial improprieties at the NRA perpetrated by its senior officers. Quote from paragraph 543. 2 of the 5 audit committee members, the audit committee chair and the interim president of the NRA, left the July 30th, 2018 audit committee meeting before the whistleblowers gave their presentation. Hear no evil, see no evil. Also, the minutes for that meeting of the audit committee failed to record the fact and the substance of the complaints from the whistleblowers, as if they hadn't, the committee members hadn't heard it. The committee chair was not even provided a copy of the Top Concerns Memo by the vice chair after the meeting. So, ostrich syndrome. What the not-for-profit corporation law provides is a roadmap to compliance with fiduciary members and officers. There are detailed provisions, and these are just some examples. The not-for-profit corporation law, as most of you know, is incredibly detailed. And so there are, for example, provisions on elections, on meetings, including detailed provisions on notice of meeting, on decision-making at meetings. There are requirements for an annual financial report. There are requirements with respect to documenting corporate meetings and decisions. There are filing requirements with the Attorney General's Charities Bureau. There are very detailed provisions on conflicts of interest and related party transactions. And so if you adhere to the provisions of the law, you are basically following a roadmap to compliance with directors and officers' fiduciary duties. On the other hand, the NRA's conduct is in fact the road to disaster, because we see what happens when the not-for-profit corporation law's roadmap to compliance is rejected or ignored. And in particular, we see that in the NRA situation, there were a string, and quite a lengthy and crowded string, of conflicts of interest and related party transactions. Quote, for years, Defendant Frazier, who was the corporate secretary and general counsel of the NRA, so the internal general counsel, failed to comply with his obligation under the NRA bylaws and internal policy to collect and submit to the NRA Audit Committee the annual financial disclosure questionnaires that the NRA board members and officers are required to fill out. And of course, this is not something, and I'm sure everyone knows this, but it bears restating that this is not something particular to the NRA's internal policies under New York law. Every nonprofit is required to A, have a conflict of interest policy, B, a conflict of interest policy complies with the law, and C, included in that policy, in addition to processes and procedures that comply with the law, is the requirement for annual written disclosure of conflicts or related party transactions, and also, to the extent that they occur during the course of the year, prompt disclosure under the policy of those same conflicts and related party transactions. For years, the Audit Committee failed to adequately address related party transactions or conflicts of interest in violation of both the not-for-profit corporation law and the NRA's internal policy governing conflicts of interest. The NRA Audit Committee failed to comply with its obligations to diligently review and approve and document such review and approval of related party transactions and conflicts of interest between the NRA and NRA officers, directors, and key persons. There's something very important buried in that excerpt from 538, from paragraph 538 of the complaint. The requirement under the law is more than just to review and approve a related party transaction, so a financial transaction with an insider or an affiliate of an insider. It's more than just reviewing and approving it. It's documenting that review and approval and having a basis for the approval. And we're going to see, I think in a minute, that was a problem that came back to bite the NRA's Audit Committee. So the NRA entered into numerous unlawful related party transactions in violation of the not-for-profit corporation law and the estate's powers and trust law. These transactions were outside of the NRA's authorized corporate purposes. The complaint notes to conduct reviews of related party transactions specifically required by the law until September 2018, which is, if you remember, right after that visit of the whistleblowers to the Audit Committee. And then in September 2018, the Audit Committee had a, quote, review and an approval of all sorts of related party transactions that they had not looked at previously, but there was minimal inquiry or detail. So basically it was a cursory, oh yeah, here's this list of related party transactions, and we see them and we approve them. End of story. And as you might imagine, that's not going to work. Under the not-for-profit corporation law and the estate's powers and trust law, the NRA is prohibited from entering into any related party transaction unless the transaction, and this applies to all New York nonprofits, is determined and documented by the board or an authorized committee, in this case the Audit Committee, to be fair, reasonable, and in the corporation's best interest at the time of the determination. So if you've heard me speak on related party transactions before, you know that I refer to those statutory words that the board or the committee has to find fair, reasonable, and in the corporation's best interest as the magic words. It's not enough to approve a transaction. The board needs to find that the transaction is fair, reasonable, and in the corporation's best interest. But even that is not enough, and that's very important, and it's a very important takeaway from this enforcement action and from the NRA's misdeeds. It's not enough, because this audit committee, in fact, looked at all those transactions that they had not looked at before and said, oh yeah, they're good, they're in the corporation's best interest, nothing to see here, move on. And that was not enough, because there was no real inquiry, and there was no basis for the board to make that determination. So documenting that basis is a critical part of what the board, or in this case, the audit committee, needs to do. So here's some basics, and we've touched on this a little, but it's critical to New York nonprofit law, and critical to every single nonprofit in New York State. In addition, every director, officer, trustee, or key employee who has an interest in a related party transaction must disclose in good faith to the board or an authorized committee of the board the material facts concerning such interest. That certainly didn't happen here, and there's lots of juicy detail about that in the complaint. In fact, the opposite happened. There was active effort to disguise and hide those transactions. And the corporation must conduct a process before approving a related party transaction and document that process. Again, none of that happened here. Similarly, the NRA's board is required to adopt, implement, and assure compliance with. So it's not enough to adopt it and put it in the file cabinet. The board is responsible for assuring ongoing compliance with the conflict of interest policy that would ensure that the trustees, directors, officers, and key persons act in the corporation's best interest and comply with legal requirements, including those concerning related party transactions. As I mentioned earlier, the policy must provide for annual conflicts of interest disclosures and procedures for the disclosure and determination of conflicts, which must prevent the person with the conflict from influencing the determination. The policy also has rigorous record-keeping requirements on the existence and resolution of conflicts. So, as we can see, and as if you've heard me speak before, you've heard this phrase, nonprofit governance is not rocket science. These are really mechanical procedures with tremendous substance, but there's a roadmap. There's step-by-step procedures, and if you follow them, you're complying with your fiduciary duty, and you're protecting the organization and the individual board members and officers. And if you're not, you are putting your organization and yourselves as individuals in tremendous jeopardy, and none of this is rocket science. It just takes careful attention to detail and determination to know the law and follow it. So something else that's paramount in the NRA complaint, there's a whole section 7, Roman 7, dedicated to this, is false regulatory filings. And as you know, nonprofits file a Form 990 with the IRS, and most nonprofits are also required to file a Char 500 annually with the Charities Bureau of the Attorney General's office in New York. And the main substantive piece of that Char 500 is the IRS Form 990, which has lots of relevant information in tremendous detail. And the Char 500 must be signed by the organization's president or authorized officer and its chief financial officer or treasurer, both of whom, by their signatures, certify under penalties of perjury that the report, including all attachments, so including all of the lengthy detail in the 990, all of that is true and accurate. So there's a certification as to the truth and accuracy of that. And this is a wonderful opportunity to remind everyone involved to very carefully scrutinize the Form 990 filing. It should be reviewed by everyone on the board, and the content of the Form 990 is a tremendous weapon for regulators and for private litigants. And so the 990 should not ever be filed without adequate review and attention to every single line item in that 990, including the schedules. The defendant, NRA, made materially false and misleading statements and omissions in its 2015, 2016, 2017, and 2018 Char 500 filings with the Attorney General. These statements included, but were not limited to, and if you look at the contents of these, and I'm going to go through them quickly, you'll recognize them if you're familiar with the 990 as all being information that's required on the 990. False statements about compensation and benefits for officers and directors. False statements about diversion of corporate assets. False statements, because you're asked on the 990, did the organization become aware of the diversion of corporate assets in the past year? False statements, and they said no. False statements about enforcement of its conflict of interest policy. False statements about its processes and procedures for determining compensation of officers. False statements about compensation and benefits to directors. False statements about compensation policies and reviews, and false statements about transactions with interested persons. And all of this is in black and white, right there on the face of the 990. So again, the primacy of the Form 990, and it's a tremendous trap for the unwary when my firm gets retained by someone who bring an action against nonprofit board members. One of the first things we look at is the 990, and very often, as in the case with the Charities Bureau, with the NRA complaint, and also with Trump Foundation complaint, it was chock full of very useful missteps by the organization, and so. In its Form 990s, the NRA falsely reported that it was not a party to business transactions with current or former officers or directors or relatives or entities affiliated with them, and failed to disclose those transactions on the required schedules of the 990. And of course, as set forth in painful detail in the complaint, the NRA has been a party to multiple business transactions with current or former officers, directors, relatives, or their affiliated entities that the NRA, in violation of the law and in violation of the certification as to the truth and accuracy of the 990 and the Char 500, the NRA failed to report all of that. On the Form 990 in 2018, for example, the NRA answered no to the question, did the organization become aware of a significant diversion of the organization's assets? Obviously, when those whistleblowers showed up at the Audit Committee with chapter and verse in writing, the organization, if it didn't know earlier, and it did, but if it didn't know earlier, it knew then. And so when the NRA answered no to the question on the 990, it was a false filing, both with the IRS and New York State. Similarly, the NRA on its 990 filings said yes to the question, did the organization regularly and consistently monitor enforcement with its conflict of interest policy? And clearly it did not. And that is based on the extensive evidence, including witness testimony, including by the perpetrators of the financial improprieties themselves. Similarly, excess benefit transactions, which are transactions that provide an excess benefit to disqualified persons, to insiders like the officers who are defendants in this action. It said no, there were no excess benefit transactions. That's what the 990 said, and clearly not the case. In its Form 990s for the relevant time period, the NRA filed false and or materially incomplete responses on Schedule J, which reports information on compensation for officers, directors, key employees, and highly compensated employees, including failing to report that the NRA paid for travel for companions until its 2018 Form 990, when in fact they finally did report it, when in fact the NRA in the past repeatedly paid for travel for Wayne LaPierre's wife and other family members, and failing to report that it provided a housing allowance, which again, it did for some officers. In its Form 990 for the relevant time period, the NRA failed to disclose in its response to question 25A on Part 4 that it engaged in excess benefit transactions and failed to make related filings. And in its Form 990 for at least 2014 to 18, the NRA failed to disclose taxable personal income for LaPierre, Phillips, and Powell, for example, as set forth in the complaint. LaPierre and Phillips permitted NRA executives and personnel to use vendor credit cards, alter ego accounts, and vendor charges to disguise payments to LaPierre on LaPierre's behalf for LaPierre's personal benefit and as reimbursements of LaPierre's personal and family expenses inconsistent with reporting requirements under the Internal Revenue Code. I want to make sure that I get to another aspect here that is noteworthy, and this is Part 8 of the complaint, and I recommend that you read the complaint, and in particular look at Part 8. It talks about the NRA's violation of its duties under the New York Prudent Management of Institutional Funds Act, otherwise known as NIPMIFA, and NIPMIFA imposes fiduciary duties and very specific processes and procedures with respect to management of institutional funds on the board and on committees of nonprofits. And so in managing institutional funds pursuant to NIPMIFA, which is part of the not-for-profit corporation law, the NRA must manage those funds in good faith and with the care an ordinarily prudent person in like position would exercise under similar circumstances. And clearly that did not happen here. The NRA has failed to incur only costs that are appropriate and reasonable in relation to its assets and purposes. And the NRA has failed to make reasonable efforts to verify facts relevant to management of its institutional funds, and we've certainly seen that. And the NRA further has failed to make reasonable efforts to keep its board and relevant committees of the board, specifically the Audit Committee, as we've seen, apprised of the financial status, risks, and commitments of institutional funds. And again, always keep your eye, if you're involved with a nonprofit in any capacity, on the need for continuous, accurate, and timely information flow to the board and to the relevant committees. And we see that come up all the time in nonprofit disputes litigation and in attorney general enforcement actions. Basically, the NRA failed to ensure that institutional funds were not subject to waste and misappropriation, and that is another basis for breach of fiduciary duty and potential liability. And on that note, I will again remind you that all of this is set forth in the law. It's not rocket science, it's something that every nonprofit board, officers, senior staff really needs to pay attention to. I thank you for your attention and enjoy the rest of today's program.